Okay, we're going to cover just a few more of the most important 803 exceptions to the hearsay rule before moving on to talking about impeachment of witnesses. So in terms of your exam, you're only going to be expected to know the hearsay exceptions that we talk about in class. So the last few we're going to talk about, we're going to start with 803.22, 803.22, which is the hearsay exception for judgments of previous conviction. So first of all, let's just talk about ways that a record of a prior conviction might be offered into evidence by somebody. So first, a record of a prior conviction can be used for impeachment of a witness, any witness in any civil or criminal case. You can put in a record of a prior conviction of that witness as an attack on the witness's character for truthfulness. We're going to be talking a lot about that in the next couple of weeks. So we're going to see that under Rule 609, a prior felony conviction might be admissible to impeach a witness's character, and a prior conviction of any kind, even a misdemeanor, might be admissible to impeach a witness's character for truthfulness if that prior conviction involved a dishonest act or false statement. So a lot more on that to come. But the other two ways, number two is a prior conviction might be offered as circumstantial evidence in a subsequent criminal case. Remember that a prior conviction can't come in against a criminal defendant if it's just offered to show the defendant's character and propensity to commit a crime. But remember, under Rule 404B, a past conviction could come in as prior act evidence offered for one of those SS Capomia non-character purposes. So for example, suppose somebody is arrested with a certain quantity of cocaine that might be on the borderline between usual amounts for personal use versus usual amounts for distribution. If the defendant there claimed that the cocaine was for personal use, a court might admit a prior conviction for cocaine distribution for the non-character purpose of tending to show intent, right? One of our I's in SS Capomia. So the last one, a judgment of previous conviction, might be offered because some fact determined in that previous criminal case is an issue in a subsequent civil case that arises from the same transaction or occurrence. So now here is basically that exact same slide, only I have used yellow font here to highlight that a record of a prior conviction, if it's offered for purposes number 2 and number 3 here, that is when we're going to need an exception to the hearsay rule, because in these two uses, the conviction is going to be offered for its truth. So it's going to be an out-of-court statement offered for its truth. So 803.22 is the exception that's going to be used in the federal system here. So why is purpose number 1 not highlighted? Well, it's because you don't need a hearsay exception to use a prior conviction for impeachment purposes, since actually by definition it's only offered to go to the character for truthfulness of the witness, so not for its truth, oddly. And so it ends up coming in under Rule 609 by itself. So Rule 609 kind of operates as a quasi-hearsay exception, even though technically it's not hearsay, because technically it's not offered for its truth, but only to go to the witness's character for truthfulness. And 609 essentially also operates as an exception to the prohibition of character evidence too, because a prior conviction obviously is character evidence against that witness, but it's not, again, because it's, the jury's given a limiting instruction saying, oh, you're just using this to go to the witness's character for truthfulness, all right? So to use a prior conviction for impeachment purposes, you don't need a hearsay exception. Also, I just want to remind you here, for studying for finals purposes, don't get confused about Rule 404B. When you're presenting other acts evidence for one of those non-character esse capomia purposes, remember that presenting a written judgment of conviction is only one way of presenting that past act evidence, right? You can also put on just an eyewitness to testify about those past acts if they fall under one of the permissible 404B purposes. So remember, you only need an exception to the hearsay rule when the type of evidence you're trying to use is hearsay. You need a hearsay exception if you want to use a written judgment of conviction for its truth, because the record of prior conviction is hearsay if it's offered to prove either guilt of the prior crime or to establish a fact that was essential to that past criminal judgment, right? A record of conviction here is essentially the unsworn, uncross-examined statement, out-of-court statement, of the trier of fact in that previous criminal case that the accused committed the crime charged. Notwithstanding that, we have this rationale for allowing a hearsay statement like this in a judgment of prior conviction. We say, well, it's reliable because there's a reasonable doubt standard, pretty high standard in that prior criminal case. So we think that judgments of previous conviction are pretty reliable evidence. All right, so here's the text of the rule with a couple of additions in red added by me. So you see in Part A of 80322, a judgment of conviction can be admitted under the federal rule if it came in after either a trial or a guilty plea, but not if there was a plea of nolo contendere. We talked about that before. Remember that, in fact, the most common reason for someone to craft a deal to plead nolo contendere is to avoid that judgment of conviction being used to prove civil liability in a later civil case. That was actually the reason for creating the whole idea of a nolo contendere plea, to avoid some of the civil consequences of an admission of guilt in a criminal case, but yet to allow a criminal case to get disposed of. And so these judgments in the federal system can only come in after a trial or guilty plea in that case. Next, we have letter B. Convictions admitted under this rule have to be for a crime punishable by death or more than a year in prison. So this is basically the definition of a felony in most jurisdictions. So shorthand here, to come in under this hearsay exception has to be a felony conviction. 80322C stands for the fact that the judgment can only be admitted to help prove a fact that was essential to that judgment in the criminal case. In other words, to prove either that the person was found guilty of that crime, or to prove some fact that was fully litigated in the criminal case on the way to that determination of guilt. So can't be admitted for some side collateral fact that wasn't totally fully litigated. And then Part D makes it clear that if a prosecutor wants to use a prior conviction in a criminal case, it has to be the conviction of the defendant. So this rule prevents the prosecution, for example, from using a third party's conviction to prove some fact in a case. The advisory committee note says, look, using a third party's conviction is almost certainly going to violate the defendant's confrontation clause right. So not allowed here. So for example, let's say a defendant's being tried for possessing stolen goods. It would be a violation of his confrontation clause right if the only evidence that those goods were stolen was a judgment of conviction of some other person for stealing the goods. That's why Section D spells this out and carves out this exception. In criminal cases, it has to be a prior conviction of a defendant. But as you can see in red here, in a civil case, you can introduce a non-party's conviction, if it's relevant and admissible for some purpose under this rule. So, for example, let's say you had a case in which a decedent's estate is suing someone for negligently killing the decedent. Now, the defendant there could actually put into evidence, let's say someone else was the person who was actually convicted of involuntary manslaughter of the decedent. The civil defendant here could put in a conviction of another person saying, look, this other person was convicted of manslaughter for killing this decedent. So you shouldn't be able to sue me for it. Also, in a criminal case, the prior conviction of a third party can be offered against the government by a defendant to show that someone else committed the crime. All right, so here are a couple of classic examples of ways a party might use Rule 803.22 to offer a judgment of a criminal conviction in a later civil case. Okay, so you could have a personal injury action where the plaintiff offers evidence that the defendant was convicted of negligent homicide due to driving drunk in a previous criminal case that arose from the same accident that caused the plaintiff's injury. So that conviction would be offered there, obviously, to show that the defendant was driving under the influence at the time of the accident. And another classic example here, let's say you have a policyholder of an insurance policy that's suing to recover on a fire insurance claim that the insurance company doesn't want to pay. Now, the defendant insurance company could offer evidence that the claimant here was actually criminally convicted of arson in the burning of the property that forms the basis for the claim. Obviously, that's going to nullify the insurance policy. So this exception could be used to bring in that judgment of previous conviction there in the later civil case. So this idea of using records of past convictions to establish facts, it's actually changed a lot over time. In the past, the general rule was prior convictions weren't even admissible in evidence, period. But then courts started moving toward treating these convictions as not only as admissible but rebuttable evidence, but in fact as being conclusive evidence on those facts established in the first case. Now that falls under these principles of collateral estoppel or issue preclusion. So in other words, any facts that were central to the prior criminal case that led to the judgment can't in fact be relitigated in the case at hand. They have to be accepted as established. Now I know that you talk about collateral estoppel and issue preclusion in civil procedure. I'm sure you remember it far better than I do. So the concepts here on this slide probably going to be more helpful for you when you're studying for the bar exam. I'm not going to test you on this, but I wanted to do a slide for you anyway. The basic rule that you might remember from Civ Pro is that if issue preclusion applies, then a judgment is essentially legally operative language, and you don't even need a hearsay rule to get it in. Issue preclusion really doesn't fall under the evidence umbrella, instead under the particular jurisdiction's law of judgment. So any proponent wanting to bring in a previous conviction would actually much rather use issue preclusion if it's available in that jurisdiction, because then the relevant facts from that previous action actually can't be rebutted. They're considered decided, and they apply to the case at hand. So the law of judgments actually requires a judge in the second lawsuit or the second prosecution to apply the law of the jurisdiction in which the first judgment was entered. So the rule is if that jurisdiction would call the judgment preclusive, it should be preclusive in the case at hand. But let's say a prior conviction isn't preclusive under the doctrine of collateral estoppel in the relevant jurisdiction, well, then it may still be admissible as evidence of the facts that were necessary to support the judgment through this evidence rule 803.22. So even though here it's a rebuttable piece of evidence, it's still going to be very persuasive to a trier of fact, obviously. Also, remember, Rule 803.22 only addresses the hearsay problem, right? So it leaves open the possibility of excluding a prior conviction on Rule 403 grounds if a judge finds the jury's going to be over-influenced by it, if that possible prejudice substantially outweighs probative value. But really, in practice, a prior conviction that meets the requirements of this rule is going to probably be admitted as long as it's being offered for a permissible purpose. In terms of California, under our Evidence Code 1300, a final judgment of conviction for a crime that is punishable as a felony, right, is admissible in a subsequent civil action to prove any fact essential to the judgment of the criminal conviction. So this section applies in California to judgments of conviction even where they were based on those nolo contendere, that nolo contendere type pleas. So two differences actually here from the Federal Rule 803-22. Number one, the conviction can be the result of trial, a guilty plea, or nolo contendere plea, and the California exception only applies in civil cases, so never in criminal cases. Okay, now let's talk about the question raised in the 1996 Stroud case that you read. That's a district court decision out of Nevada, which of course is in the Ninth Circuit. So remember, the issue there was whether a conviction that didn't satisfy Federal Rule 803-22 could still be admitted through a different route. And there they tried to get it in under the public records exception of 803-8. So why didn't the conviction here qualify for 803-22? Well, because it was a misdemeanor conviction. Misdemeanor conviction for failure to use due care in connection with the car accident that led to this civil suit. So I've reminded you on the slide here, Rule 803-8A3 does contain that provision allowing factual findings, right, from a public record to be admitted if they were made pursuant to authority granted by law and if they're offered in a civil action or against the government in a criminal case. So the language of 803-8 taken just by itself seems to apply to a situation like we have in Stroud. But just like in so many other circumstances in the law, you have to look at the rules all together, maybe in concert with other rules. So we saw here Judge Reed very reluctantly let this misdemeanor conviction in part because he was bound by the Ninth Circuit Appellate Court decisions that upheld admissions of records of misdemeanor convictions under 803-8. But you did see him making the point that he disagrees with that precedent because there's a pretty strong expressio exclusio argument. In other words, that the fact that 803-22 does single out felony convictions, that likely also carries along with it the negative implication, as in, well, if the crime wasn't punishable by a year or more, it wasn't intended by the rule drafters to be accepted from the hearsay rule. Plus, it's kind of hard to see what purpose 803-22 would even serve if you could just use the public records exception every time to get in a judicial conviction. Why would the framers even bother with this extra hearsay exception? And again, you could also cite that old maxim that in the law, the specific should control over the general. So here, 803-22 drafted specifically with a view toward the potential problems inherent in the evidentiary use of criminal convictions, whereas 803-8 is a broader rule about public records in general. So Judge Reed admits, though, that the Ninth Circuit precedent requires him to admit the conviction, even though he disagrees with the precedent. He thinks the Fourth Circuit had it right in not allowing the public records exception to be used that way. I personally think that the Fourth Circuit was probably right as well, but there is a circuit split in reality. Admission of a misdemeanor is going to depend on where you are, but in the Ninth Circuit, it seems like it will be allowed. Okay, next you had some reading on the miscellaneous exception for treatises and other professional literature. Okay, so and you read that great excerpt from Wellman on the art of cross-examination, which is pretty entertaining. So even though this rule is considered one of the miscellaneous rules and it falls way down in number 18 in the Rule 803 exceptions, it's actually really important for cases in which expert testimony needs to be presented to the jury and in which the other side's experts need to be cross-examined. So this rule sets forth a pretty generous exception for admission of statements from learned treatises and other expert publications. And this allows introduction of passages from books, scholarly journals, technical magazines, and any other published works on any science or art, as long as a foundation has been established that the work is a reliable authority. So this exception, based on the theory that most learned publications are reliable enough to be helpful to a trier of fact, certainly the author of the publication doesn't have a bias or interest in a particular legal case, even though he or she might have a bias about a particular theory on some topic. Also, the author of the learned treatise realizes her work's going to be read and evaluated by other members of the same profession. So the idea is authors of these kinds of treatises and books are going to be motivated to be accurate and complete. So when this federal rule was adopted, it made some really substantial changes compared to the common law. So the common law theory was learned treatises could only be admitted for the purpose of impeaching the other side's expert. So they weren't considered hearsay there because they were only offered for impeachment to show that an expert was unreliable, not supposedly offered for their truth. And in some jurisdictions, the opposing side expert couldn't be impeached with a treatise unless that expert had actually testified that he or she had relied upon that particular treatise in preparing an expert opinion. So that goes along with the view that the treatise wasn't going to be used to prove the truth, but only to show that the expert was unreliable. So suppose, for example, we have a case in which a plaintiff's expert testified, oh, a patient's spleen should be removed only if it's severely damaged. Okay? And imagine that the defense attorney there has a treatise that says, oh, the spleen should actually be removed even if it's suffered the slightest bit of trauma. So the defense attorney could ask the opposing expert, did you rely on this particular treatise? And if the expert said yes, the attorney could then read the damaging passage to the jury or even require the expert to read it out loud. So the idea then in the past was the treatise wasn't being admitted under a hearsay exception because it wasn't hearsay, it was just used to show that the expert was careless. So you saw in that Wellman excerpt on page 468, impeaching an expert with a learned treatise who claimed to have relied on that treatise is super impressive, very dramatic. Okay, but that example was almost like something out of the movies or a TV show, because in that situation, everything has to go according to the cross-examiner's plan for it to work out. So you could certainly imagine that kind of thing being a once in a career kind of thing, right? Wellman let this opposing expert go on and be patronizing and make jokes. And then he got his dream answer to the question about that Erickson on the Spine book, right? The expert said, oh, yes, I relied on that treatise, even though the cross-examiner knew the treatise actually contradicted him. But you should assume most experts aren't going to fall into that kind of trap of claiming to have relied on an unsupportive treatise. They're either going to deny relying on a treatise they know disagrees with them. Maybe they'll deny relying on any treatise. So the problem with this old common law rule was that an expert could always short circuit a cross-examination by just denying reliance on a treatise informing an opinion. Some common law courts actually went even a little further. Even if the expert denied relying on the treatise could still be used in evidence if the expert was at least willing to concede that the treatise was a reliable authority. But that approach still allowed the expert witness to block cross-examination simply by refusing to concede that the treatise was authoritative. So the federal rulemakers thought, well, a learned treatise ought to be admissible if its reliability can be established by any means, whether or not the opposing expert is going to concede that it's authoritative. And the advisory committee note says lawyers should be able to freely explore on cross-examination an expert's knowledge of and attitude toward any established treatise in the field. Okay, so what do you need to know about this rule? Well, there's two prongs in the rule for laying a foundation for admitting a statement from a learned treatise, corresponding to Part A and Part B of the rule. So first I'm going to talk about B, and then I'm going to talk about A. So the first element, which is in 803.18b, is showing that the work is authoritative. This can be done in three ways that I have on the slide. You can establish the treatise as a reliable authority through testimony of your own expert witness. or the opposing expert can be used to establish that the work is authoritative if he or she is willing to concede that point. And again, even a grudging concession that the treatise is somewhat authoritative, probably enough to support admission. But then the third way, the treatise can also be established as authoritative through judicial notice. Now, this concept of judicial notice is really only supposed to encompass things that are beyond doubt, beyond debate. So it seems that this would almost never really be appropriate in this context. But high-level evidence scholars have suggested that if the case situation was appropriate, a trial judge should be liberal in allowing proof of authoritativeness outside of the testimony of an expert. So, for example, with a treatise on standards of care in medicine that's offered in a medical malpractice case, a court might accept a syllabus from a medical school course as evidence of a treatise being authoritative because it's on that medical school syllabus. Or maybe a judge could take judicial notice of books admitted in similar litigation in other courts. But certainly, by far, the usual process for a lawyer to establish that a treatise is authoritative is just through testimony of probably that lawyer's own expert witness. Then, the second prong, which is in 803.18a, because of the danger that the treatise, even if the treatise is reliable in itself, because of the danger that it might be misleading and confusing to the jury without the guidance of an expert, the rulemakers did require that an expert be available and that the treatise be shown to the expert on the stand. Okay, so the expert isn't required to actually explain the treatise, but an expert has to be available if either party wants to ask questions about the treatise. Okay, and then the final sentence of 803.18 provides, if admitted, the statements may be read into evidence, but may not be received as exhibits. So in other words, the lawyer or the witness can read a passage from the treatise to the jury once this foundation has been established and permission has been granted by the judge, but the jurors aren't going to be allowed to take the treatise into the jury room to read themselves. Okay, that's the end of this video lecture.